أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم اللهم صل على سيدنا محمد وعلى آل سيدنا محمد وأصحابه وبارك وسلم. Amma ba'd, to all those present in the masjid and all those viewing on the different social media platforms, I greet you with our beautiful greeting of Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. I know it's normally outside of the month of Ramadan, this is the time we're having lunch, but I see a lot of the guys are looking very down. Let's all put a beautiful smile on. There we go, that's much better now. Shukran so much for that. On behalf of the Imam and the trustees and the executive committee, I'd like to welcome you to this, the first of our two seminars in the blessed month of Ramadan. The second one, another very important topic, and I'll elaborate upon that a little later on. But for now, today, we have a topic and a matter and an issue that really should be foremost and uppermost in the minds of every Muslim from the time that you have the capacity to think for yourself. It is an issue ultimately between you and Almighty Allah subhanahu wa ta'ala. And this issue has dire consequences for you in the akhirah, but planning for it in the dunya as well. And I've consulted with Sheikh Abdul Rahman, who has agreed with me that in the Holy Quran, by way of an introduction, Almighty Allah does not clarify and specify and amplify how we should make salah. He implores us to make salah, but our beloved Nabi Muhammad sallallahu alaihi wasallam gave us all those directives and how to make salah or when to make salah and the different forms of salah. But on the other hand, the Holy Quran, Almighty Allah through the Holy Quran has made it abundantly clear, in absolute clear terms, what we should do with that amana, that wealth amana that we have, and when we are not on the dunya one day, what happens to that? So the issues basically is the issue of the will, and after that we have experts who will talk to us about the whole question of estate planning as well. So for now, the overview of the program, inshallah, is going to be that we have a absolutely formidable panel here, alhamdulillah, two gents and a lady, absolutely formidable. And as I'm going to read out their CVs, it's going to make you very, very proud of the talent that we have within the Muslim community of Cape Town. But the overview is going to be that each speaker, each panelist will speak for 20 minutes on the topic. Thereafter, you are more than welcome to field questions to them. Just want to make it clear that it should be questions and not long statements, because we do want to finish by 3:30. So questions are more than welcome. Also note that we are feeding live on YouTube to the globe all over the world, and that please wait till the microphone is on before you answer your question. Otherwise, the technical people cannot pick up the question. But we'll elaborate a bit more about that a little later on. But for now, I'd like to ask our beloved Imam, Sheikh Abdul Rahman Alexander, to open up today's seminar with a dua, inshallah, and a few words as well, inshallah.
Al-Fatiha. Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. والصلاة والسلام على أشرف المرسلين سيدنا ومولانا محمد وعلى آله وأصحابه أجمعين. اللهم اجعل جمعنا هذا جمعا مرحوما ومباركا، واجعل تفرقنا من بعده تفرقا معصوما، فاغفر لنا وارحمنا وعافنا واعف عنا واحفظنا يا الله من كل بلاء الدنيا وعذاب الآخرة. اللهم افتح لنا بالخير واختم لنا بالخير، واجعل عواقب أمورنا بالخير، بيدك الخير والعافية، إنك على كل شيء قدير. وصلى الله على سيدنا محمد وعلى آله وأصحابه أجمعين، وسلام على المرسلين، والحمد لله رب العالمين. Assalamu alaikum wa rahmatullahi wa barakatuh. Alhamdulillah, on behalf of the Imamat of Masjidul Quds, I would like to extend a very warm and hearty welcome to each and every one of you to our first seminar for this Ramadan on the topic of inheritance. Will it be a lasting legacy or a nightmare of discord? One can never overemphasize the importance of this very, very important topic. And it is for this reason, because we as Imams sit with all the various kinds of problems, including when a woman come or a person come and the person that is supposed to inherit the testator died without a will or leaving any dictates behind, what a negative impact it has on society. And it's for this reason, with consultation with Hamare Janab Satar Parker and the rest of our committee, we have decided on hosting this very important seminar in order to enrich and empower our community, that we will not be faced with devastating effects, inshallah. So welcome to each and everyone, and I'm sure that the very formidable team that we have here today will be able to enlighten us and also answer our questions later. Jazakallah khair, shukran, and baik terima kasih.
Shukran very much, Sheikh Abdul Rahman. Anyone that does not want to pose a question verbally, you're welcome to text the question. You want to take the number down, I'll read it twice, well, mention it twice, 084 2588 786, 084 2588 786. Inshallah. Our first speaker is Sheikh Munir Abdul Rauf, who hails from an extremely distinguished family in Cape Town. He studied his LLB degree in Sharia at the prestigious University of Medina in Saudi Arabia. He proceeded with a second LLB in law from the University of the Western Cape. Thereafter, he proceeded with a master's degree in law, again from the University of the Western Cape. And alhamdulillah, finally, a PhD in constitutional law from the University of the Western Cape. He is currently a senior law lecturer at UWC, a senior guest lecturer at IPSA, a member of the MJC Fatwa Committee, Imam at the Masjid Abdul Rauf in Highlands Estate, an attorney of the High Court of South Africa. Jamaat and viewers, the topic for Sheikh Munir Abdul Rauf is, it's your will, but is it according to Allah's instruction? Sheikh Munir Abdul Rauf, inshallah.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على خير خلق الله وعلى آله وصحبه أجمعين ثم أما بعد. Respected ulama, respected elders, beloved brothers and sisters in Islam, I greet you all in the universal greetings of love, mercy and peace. Assalamu alaikum wa rahmatullahi wa barakatuh. Inshallah, in the time given to me this afternoon, I will be looking at the topic, your will, Allah's instruction. Your will, Allah's instruction. And the main focus is, how do I know that what I am pointing out in my will, with my attorneys, with my advisors, is in accordance with what Allah subhanahu wa ta'ala had instructed in the Quran, primarily in chapter 4, verses 11, 12 and 176, and expounded upon in the prophetic narrations and traditions of Nabi Muhammad sallallahu alayhi wa sallam. Now the reality is that each and every one of us over here in plus minus 50 years, with a very exceptional few, will and would have passed on. There will be new people sitting here, and we would have been passed on. As Allah subhanahu wa ta'ala says in the Quran, كُلُّ نَفْسٍ ذَائِقَةُ الْمَوْتِ, that every soul shall taste the death, each and every one of us. Now, we all acquire assets, items during our lifetimes. Now, from these items, it might be in our possession when we pass on. And my presentation today will look at what should happen to these items once we have passed on. And how do we ensure that these items are distributed to the rightful owners in accordance with the laws of Allah subhanahu wa ta'ala. Now firstly, when that ayah finds application, كُلُّ نَفْسٍ ذَائِقَةُ الْمَوْتِ, when I have been chosen and Malakul Maut extracts my ruh, the items that I have left behind, it might not all be my items. It might be an item, a laptop that I've loaned by the University of the Western Cape. It might be a cell phone that is laying in my office, and so forth and so forth. There might be some money that I've loaned from my friend in order to pay some debt. That is part of the liabilities against the estate. Now in these instances, Jama'at Muslimin, ladies and gentlemen, it is our responsibility as a first point to ensure that when we pass away, that the items that are in our estate, that does not necessarily form part of our ownership, is in our possession, yes, must be then returned to the rightful owners. So it might be that when I pass on, I have the cell phone. And then what happens? My son says, my daughter says, no, it's my father's. But because I did not enter into a contractual agreement of loan, there would not be any evidence to prove that this must be returned. What then happens? The rights of an individual is then taken and it forms part of my inheritance. And the Prophet ﷺ in this regard stated in a hadith that we hear on so many times on the radio station, we should not let 2 nights pass and we have some type of a wasiyah, something to write down, and we should do so, and that should be beneath our pillows. Now that hadith is generally used incorrectly by referring to the wasiyah of the 1/3 that we'll discuss a bit later on. But this hadith actually refers to returning items of those who are entitled to it to the rightful recipients. So if I know I have this book or this laptop, I should write down there, if I pass away this evening because I didn't take any witnesses that confirms that this is not mine. For example, if I pass away, my executor must ensure that this laptop should go to Buddha Ahmad, Buddha Amin, and so forth. All the items in our possession at this point in time that is not ours, we must ensure there is some document that would ensure that it does go to that person, as per the instruction of Allah subhanahu wa ta'ala. If not, then put it in the last will and testament. Have it written down and have it put beneath your pillow, as we don't know if we will wake up tomorrow morning. Thereafter, the estate that is left behind, that is now in our ownership, is what is referred to as a gross estate. The estate prior to any liabilities. And all creditors must then receive from that estate as a first claim against the estate. If you look at the longest ayah in the Quran, Ayatul Dain, it's like a whole page in the 15-line Quran. It basically speaks about how do we enter into a commercial transaction. reduce it to writing, have witnesses, have two male witnesses. If you don't have two male witnesses, one male and two females, and so forth and so forth. To ensure that at that point in time, when we do pass on, besides the assets that must be returned, there might be some creditors that must be paid, and they come knocking on your door. You must ensure that they will be given what they are entitled to. As the Quran, in chapter 4, verse number 11, Allah subhanahu wa ta'ala does speak about inheritance. That is correct. And the children and the parents and the spouses, yes, they do come and they demand their inheritance. But Allah subhanahu wa ta'ala says in the Quran that they are only entitled to whatever is left after the debt has been deducted. After all, the liabilities have been settled, at least been deducted from the estate. And the Prophet ﷺ used to enter a mosque of this nature in his time, ﷺ, and he used to see that the mayyit, as we will also be laying here one day, either this mosque or in another mosque. And the Prophet ﷺ would ask the question, أَعْلَيْهِ الدَّيْنِ, does this person have any debt? If the answer was in the affirmative, if the answer was yes, the response of the Prophet ﷺ was, he turned around, he left, and he said, صَلُّوا عَلَى صَاحِبِكُمْ. He said, you make salah on this person, on your companion. Jama'at Muslimin, Janazah Salah is what we refer to as fardu kifayatin, a communal obligation, which means that it must be done, yes, but not everyone has to do it. If no one does it, everyone will be held accountable. But if someone does it, it falls off the shoulders of the rest of the ummah. Fardu kifayatin. In this regard, the Prophet ﷺ was making a statement that is not encouraged to pass away while having debt. In a future occasion, the Sahaba was standing in the mosque again, another janazah salah, and the Prophet ﷺ was asked to perform the salah on the janazah. He asked, أَعْلَيْهِ الدَّيْنِ, does this person have any debt? And the answer was yes. The Prophet was about to leave and said, صَلُّوا عَلَى صَاحِبِكُمْ, as in the previous occasions. In this instance, the one Sahabi stood up and said, Ya Rasulullah, O Messenger of Allah, look here, I'll sort out the debt. Please make salah on this person. The Prophet ﷺ said, are you making salah? Are you paying this debt? And now he owes you, or is it being paid and there's no more creditors? He said, don't worry, I'll pay the debt, and he does not owe anyone anything. The Prophet ﷺ said, all right, if that be the case, I'll make salah on him. The next waqt came after the salah had been performed, and the Prophet ﷺ asked that companion, did you pay that debt? He said, no. He said, I'll pay the next waqt. After 2 waqtus, finally the debt was paid, and the Prophet ﷺ said, now the punishment has been lightened. Jama'at Muslimin, we don't play around with debt. As far as the deceased estate is concerned, it might be once the debt has been paid, there's nothing left for the bequest, for the wasiyah. There's nothing left to the mirath. And then the children and parents, they have to go back. There's nothing for them. But in the instance that there is something left for them, Allah's instruction is that after all liabilities have been deducted, it might be, we have many women here, you have entered into an agreement with your husbands that when upon marriage, I want a house. Sometimes it happens, and sometimes the husbands agree. But the husband doesn't have the money at this point in time, and he says, I'll give you the house in 10 years' time. The house is worth 2 million rand, and he agrees. But then he passes away 2 years later. She can claim that house against the estate as a liability before inheriting as one of the waratha in terms of the laws of compulsory succession. That is a right. Thereafter, whatever is left, that is then distributed according to what Allah subhanahu wa ta'ala says is after the debt and after the wasiyah. Let's say, in this instance, the person passes away leaving behind 1 million rand. Right? We have given back all the items that is not his or hers. We have paid all the debt. We have given whatever is entitled to, whatever, we have paid for the janazah expenses, we're now sitting with 900,000 rand. As per Allah's instruction, Allah subhanahu wa ta'ala then allows each and every one of us then to bequeath a maximum of 1/3. 1/3 of the net estate after all liabilities have been deducted and all other items have been removed from the estate that is not his or hers. 1/3 that you can give away. In the event where you decide to give away that 1/3, also take into consideration how big is your estate. If you have a very small estate, then don't give away that 1/3. Leave it to your children. There was one Sahabi came to the Prophet ﷺ and he said, "Look here, my estate is quite big and I would then want to give everything away. My daughters are sorted out. Can I give away everything?" The Prophet ﷺ said, "No, you can't give away everything." He then came back and he said, "All right, can I give away half of my estate?" He said, "No, that is too much, you can't give away." Then he came back, he said, "All right, can I give 1/3 of my estate away?" A sadaqah, obviously towards a good cause, and there are certain requirements that must be met. It can't be a compulsory beneficiary, it can't be something haram, and so forth and so forth. But we're looking at the portion of the estate as per Allah's instruction. The Prophet ﷺ says, "Athuluthu wa thuluthu kathir." He says 1/3 is maximum and 1/3 is a lot. Rather leave that money for your heirs. Leave it to your heirs. And they can make use of it instead of them having to go and beg by people. Obviously, that is only in the instance where you have a small estate. Alhamdulillah, I think many of you have big estates. So Alhamdulillah, you can give up to that maximum 1/3. Now, after we have deducted that 1/3 from the estate, as per Allah's instruction, it could be that I gave everything, that complete 1/3, which means of that 900,000 rand, it would mean 300,000 rand towards Masjidul Quds, for example, which leaves us with a balance of 600,000 rand. Or I might have left nothing to Masjidul Quds or any other institution, which leaves that 900,000 rand to my waratha, to my compulsory beneficiaries, to share between them as per the Quranic injunction. Let's say they gave 300,000 rand to Masjidul Quds. We're sitting with 600,000 rand. Now that 600,000 rand, there we have no say at all. Allah subhanahu wa ta'ala says, "This is my order." Now what's important to note at this point in time, sometimes they say, but my daughter, my son, this, that, and the other. If you want to do something of that nature and you want to give something to someone, you can do so, as these laws only find application once you pass away, once you close your eyes. But if, for example, before you pass away, you have 5 houses and you want to give each of your children, your sons and your daughters, 1 house and transfer it onto their names, you go to a conveyancer, you pay whatever taxes needs to be paid, and then it's sorted out, then they all have their houses. But you can't say, once I pass away, this is what I want to happen. No, my one daughter, she has enough houses. My other son, he's sorted out. I'm giving everything to my last son. No. Because Allah subhanahu wa ta'ala had ordained in those verses, 11, 12 and 176, as to what should happen to the estate once a person has passed away. So the reality is that you are allowed to make use of this opportunity to give a gift. It might be that you only have a house and you very much want to give the house to your wife. All right? Because if you pass away, your children will inherit and so forth. And you really want to give it to her. All right, so you can give it to her. Transfer it onto her name. Then it is hers. Or if the house is in the husband's name, you can give it to the wife. Or on the wife's name, she can give it to the husband. Or you can transfer usufruct. In terms of the Sharia, there's something referred to as an umrah, where I'm the owner of it, but I give it to my wife. For the rest of her life, she can stay in the house. So even if I pass away, she can still stay there, even though the property will be distributed, ownership will be distributed, or the bare dominion will be distributed to the beneficiaries. but the usage of that asset will continue until she passes away. And this fatwa has been accepted by the Muslim Judicial Council as well. So there are certain advantages to these type of distributions. But thereafter, the rest of the estate must be distributed in terms of Sharia. The most basic wills you'll find, and Brother Shaukat, he will speak about the more complicated wills, is where a person states in the last will and testament, obviously after ensuring that all items not yours has been seen to, it will go to the rightful beneficiaries. All liabilities will be seen to, the wasiyah has been sorted out, the rest of the estate. You could state in your last will and testament, I leave it according to Sharia. Right? And for purposes of giving effect to this clause, I leave it up to an institution like the Muslim Judicial Council SA to ensure that they draft an Islamic distribution certificate stating who my lawful heirs are at the time of my death. And the reason why I say there that at the time of my death is because at this point in time I might have 4 daughters, I might have a mother, a father, and I might have 1 wife. At the time of my death, I might have a son, which changes the scenario. My parents might have passed on. My wife might have been passed on or divorced, whatever the instance might be. And it might then be at that point in time of my death, the will that was Sharia at the time of execution, of signing, was Sharia compliant, but at the time of my death, it is no longer Sharia compliant. And that is what Sheikh Abdul Rahman basically was referring to, where there is a will, or a scenario of where there is a will, but that will does not go according to Sharia. So to conclude, the estate, in terms of Islamic law and Allah's instruction, should be as follows. Everything that's not in the estate, not your ownership, must be returned. Thereafter, all liabilities must be deducted. Thereafter, the wasiyah can be given up to a maximum of 1/3, and thereafter the remainder of the estate, that must be left up according to what Allah has stated in the Quran, and you can look it up for yourself in verses number 11, 12, and 176 of Surah An-Nisa, that explicitly states how that estate should devolve. Inshallah, I think my time is up, and I hand back over to the MC. Shukran, wa yatafaddal mashkura.
Shukran very much, Sheikh Munir Abdul Rauf. I'm sure you'll agree with me that he's managed to put the waters of an ocean into a bottle. It's a very huge topic, but he summed it up very beautifully. Sheikh, for a minute, you were my friend, and after that's after you made the pronouncement that the 300,000 rand must come to Masjidul Quds. But when you change that around, I'm not so sure about the friendship anymore. That's only tongue-in-cheek. The one question, I've been getting quite a lot of questions on the phone, but Sheikh, maybe you can just address this one quickly. That wasiyah, can it be to anybody, non-Muslim as well?
Shukran for that question. As far as the wasiyah is concerned, there are certain restrictions, right? It cannot be more than 1/3 of the net estate. But to answer your question, yes, it can be to a non-Muslim as well. So it could be to a Muslim or non-Muslim. And that normally happens in the instance where, let's say, the testator was non-Muslim and he became Muslim, and automatically certain persons were disqualified, let's say his parents. So now he makes a wasiyah in their favor. And the rest of the estate, that compulsory inheritance, should then be distributed according to the Sharia, and that is where the non-Muslim does, however, become disqualified. Shukran.
Shukran very much for that, Sheikh. The other question was that this obviously is all applicable post-death, after death. Is that correct?
Yeah, that is correct. That all of these laws only apply once you pass away. So any gift that has been given to a friend or a son or a daughter and ownership has transferred, then that is out of your estate, and obviously that asset wouldn't be applicable to the laws of inheritance.
So the question that came after that, sorry, I'm imposing like this, but I just thought it's relevant to your talk, that during your lifetime, whatever money you have, you can do what you want to with it.
Yeah, as long as it is in terms of Sharia as well, so in not haram or anything like that. But you can, for example, give all your children equal properties in your estate, for example.
Okay, shukran very much.
Shukran.
Thank you so much. Thank you very much for that clarification. Jamaat and viewers, our next speaker is a lady, again practicing as an attorney since 2001, holds a B.Proc degree and then a master's in law, director of the Women's Legal Center, and she advances women's rights in a society dominated by men, board member of the Lawyers for Human Rights, a passion for women's rights, and a community activist. And she will be speaking on a very, very important aspect of today's conversation, the effect all this has on our wives, our mothers, our daughters, and our sisters. It gives me great pleasure to call upon Siham Samai.
I think I'm going to do this. Yeah. Assalamu alaikum to everyone. It's wonderful to be here. Also from the Women's Legal Center, where I've litigated on Muslim personal law for many, many years. And I'm here to be able to just give our experiences over the past 25 years on what happens either if you have a will or when you don't have a will. Sheikh Abdul Rauf has indicated that when there is a will and that you will be able to, in South African law, to be able to draft a will. That means that you have freedom of testation. It means that you've got a right to be able to put that which is required in the will and to be able to be distributed. But one of the challenges that we do have is that when there is no will and you are in a South African context, and there are many, many scenarios that I can maybe give examples of, but the most fundamental is that if you die without a will, what happens to the women, what happened to the children, what happened to the heirs? Now, in South African law, if you die without a will, then automatically the South African law applies, which means South African law is rooted obviously in Roman Dutch law, etc., and it has its own distribution in terms of intestate to ensure that the children and the wives or the spouses, etc., they do at least access that which is in the estate. There are many reasons for that, because one of the challenges were first that women could not inherit. Secondly, there was also a very broad rule, which is the head of the household, and women are either left out of the will and children do not get the will. So over a period of time, this changed, and I think it's very important to speak within a South African context. Because South Africa in itself comes from an exceptionally patriarchal society, and women could not own property, or Muslim women that were married, that means specifically Muslim women married in terms of Islamic rights, more times than not, did not own property. The challenges is that when the person dies without the will, how does the distribution work? One of the first, and let me just explain, one of the legacies of our apartheid state was that there was a very particular ethnocentric policies which looked at Christianity broadly as the basis for distribution or also for the concept of marriage, which meant that spouse did not include a Muslim spouse. That had a major, major impact pre-1994. We had a legacy where, for example, there was the case of Sidat and Ishmael, which it provided a context where the cases deemed Muslim marriages void on the grounds of public policy, and it was intertwined with notions of Christian marriage and morality, and there was no regard for broader cultural diversity or religious diversity. Over the past 20 years, obviously we litigated, and one of the first cases that came before the court to be able to broadly first recognize the Muslim marriages was Rylance versus Idras. And one of the positive developments was that while marriages were not fully recognized, the case enabled Muslim marital responsibilities to be judicially enforced. Now, this is very important because this might be in the context of marriage and maintenance, etc., and divorce. And we are talking here about inheritance, but the mere fact that the court took steps to recognize the Muslim marital relationship, the Muslim marital responsibility as a broader contract, it gave us rights, which meant that women in particularly could access rights. In 1998, what happened was that it was the Ahmad case. The applicant claimed damages in the High Court for loss of support because her husband died in a car accident. And the challenge that you're sitting with, imagine that you have children and you are destitute and you are now not recognized as a spouse within what they then call, or the multilateral motor vehicle accidents, which now today we call the Road Accident Fund, and they could not claim. So the court recognized that parties to a de facto monogamous, and this was also very important, at that point in time, they did not recognize polygamous marriages, should be awarded the same damages as parties to a civil marriage, and also court noted that approaches in this particular matter was inconsistent with the ethos and tolerance of our new democracy. I think it's important that we see here the positive development is that now you will be able to be included as a spouse. In 2004, the Daniels matter, which was one of the cases of the Women's Legal Center, the Constitutional Court decided that a Muslim spouse in a monogamous Muslim marriage has the right to inherit and claim maintenance from her deceased spouse in terms of the Intestate Succession Act and also the maintenance claim. So what does this mean? It obviously means the person left without a will. This has consequences because clearly it's not going to be allocated or distributed in terms of the Islamic principles which are set out by Sheikh Abdul Rauf. But the challenge that we're sitting with in a country where we are a minority and women have historically been disadvantaged, it was important for the Women's Legal Center to ensure that these rights of women, in particularly maintenance rights of women, are seen to once that estate is distributed. Because if the woman wasn't recognized, the estate would have gone completely to the children, and the challenge is, at the end of the day, it means that she's being disinherited from her share, and also she can be evicted from her home. So the court attempted to give meaning, and they interpreted spouse to mean also Muslim spouse. However, obviously we are now talking about polygamous matters, and the court also subsequently included polygamous marriages, which is very important. There were many other positive developments, but I think those two acts, which is the Maintenance of Surviving Spouses Act, as well as the Intestate Succession Act, now includes Muslim spouses, which predominantly, I would say, because women in South Africa are disproportionately impacted by a range of issues, which includes Muslim women. They can get a portion of that particular estate, and they can claim maintenance. Recently, also in addition to that, when you do have a will, in the case of Musa and others, the challenge that we had was, in that matter, it was a polygamous marriage, but the one partner was married in terms of community of property, and the other one was only married in terms of Muslim marriage. The challenge is that the court, or not the court, the state did not recognize spouse in the Muslim context, and everything went to the wife that was married in community of property. That was challenged also by the Women's Legal Center, and to be able to say that that the recognition should be similar. And the court then read into the provision of 7.3 also that of a wife in a polygamous marriage. So these are all within the context of intestate succession. And if the challenges that we have seen is that if you do not have what they call a usufruct, or you do not include it in your will, the challenge is that they can lose their home, their maintenance, and there are various challenges that women and children go through if the succession planning is not done proper. I also think that within the context of an Islamic will, so in an intestate, or even though it is not in accordance with the Islamic division of estate, at least there is protection for women in South Africa if they are left out of a particular will or there has been no will. If there is a will, one of the challenges that we have seen, and it has come up more and more, and I don't know whether or not Sheikh Abdullah have even, it's a challenge where the distribution is done in a manner and the wife, who is an elderly person, are normally given a share which does not allow her to maintain her lifestyle and that which is required. Because Muslim marriages is still not enforceable, I would not say not recognized because of the recent court case that recognizes Muslim marriages, and it has instructed the state to be able to come up either with a broad legislative framework or incorporate, but they have to do something to be able to ensure that Muslim marriages and or the consequences of such, which is through divorce or in terms of inheritance, are recognized. We need to be able to look at it within the context when they do an Islamic distribution will. The challenge that we always said was, and it might be right and it might be wrong, it's not sufficient. The elder son is not looking after or maintaining the mother or the daughters. And what we have seen is that they have lost their homes through that process because it is not enforceable. It is the law that is tested, and we need to be able to look at how do we enforce that women and children are not disadvantaged, sadly, because of a will that has been drafted in such a manner that does not take into account that it is not an entire system, that takes into account that the elder son must ensure that there is maintenance for the mother, ensure that there is maybe for the children in terms of the Quranic principles. And this is some of the challenges that we are looking at. Cases that have come before us is exactly that, where mothers have come to our offices in terms of an Islamic will, and we are now forced to bring an application in terms of the Maintenance of Surviving Spouses Act against an Islamic distribution will, because the mother or the children are going to sit without a home. And I think we need to be able to look at the distribution of our will and the drafting of our will to be able to ensure that our mothers and children are taken care of in a manner which is enforceable and takes into account the lived reality of South Africa, which means that we do not live in a country where we make the rules, but we do have the freedom of testation to be able to have an Islamic will. But we also have the freedom of testation to ensure that mothers and children within a South African context are taken care of, and we ensure that there's a transformative way of either interpreting or ensuring that they are taken care of. Because if there was enforcement, then I would have said 100% we need to be able to look at distribution of wills. But if we don't have enforcement, the challenge is, what are you going to do if they don't do what is required in terms of that will beyond that which has been allocated? What happens if that son does not look after that mother? What can you do in terms of South African law? Because clearly, if there is non-enforcement, there is nothing you can do other than going to court or to be able to use the state mechanism to start including women and children within that process. There are still many processes. Since 2 years ago, there are a few bills or processes that the state has started to ensure that Muslim marriages broadly are recognized, including the consequences. But the state has to do this by March 2024, which is next year. And we have not seen any broader consultations yet, but we need to ensure that what is required in the Quran and what is required for our mothers and children are reflected in what the state either is going to bring in or also what the court decides if a case goes to court again, and to ensure that those protections are there. If there are any specific questions, then I will answer, but I think I've taken my 20 minutes. Shukran.
Thank you very much, Siam. Very, very passionate advocate. And obviously she comes across with lots of experience at the Women's Legal Center. Siam, one question that came through now was that, would you say that over the last couple of years that the courts have become more sympathetic towards the plight of the ladies, of the women?
Yes, yeah. Over the past, I would say 14, 15, or I would say 20 years, since Rylands versus Idras, the courts and not the state, which since 1994, since the establishment of the first Muslim board, there has been no legislation. And it has been the courts that have come to the protection of Muslim women over the past 20 years. Whether or not it's through the Intestate Succession Act and through ensuring that Muslim women are seen as spouses. So it has been the courts. But it's done in a piecemeal manner, which means that it took us 14 years to get to the recognition of Muslim marriages and ensuring that there is an obligation on the state, an obligation which they did not want to take, and to ensure that there's an obligation to regulate the Muslim marriages and the consequences of that. So yes, so hopefully, but like I said, it's an expensive process, it's a long process, it's tedious, and many women cannot really go through the rigor of keeping 14 years. And so the state needs to come on board, and they need to be able to ensure that there's legislative protection.
Thank you so much.
The courts
Thank
have
you,
done
sir.
enough.
Thank you. Ladies and gentlemen, our final speaker for today, last but most definitely not least, is a man who's synonymous with the whole question of estate planning. Just for clarification, the will is the foundation of the matter that we're talking about, the will. Estate planning is what happens once we have the will all sorted out in the way that we feel it should be done. Shaukat Muqaddam has got a BCom honors in taxation, a chartered accountant, a fiduciary practitioner, a founding director of Legacy Fiduciary and Estate Planners, a trustee and deputy chairperson of that iconic institution, the South African National Zakah Fund, for whom he has served more than 40 years of his life. And Shaukat will take us through the whole question of, once you have a will, the whole question of estate planning. Shaukat Muqaddam.
Alhamdulillah, alhamdulillah rabbil alamin, wassalatu wassalamu ala ashrafil mursaleen, sayyidina wa nabiyana maulana Muhammadin wa alihi wa sahbihi ajma'in. Respected Shaykh, brothers and sisters and elderly, assalamu alaikum wa rahmatullahi wa barakatuh. It's indeed a pleasure and honor to be here, I think, on a very vital topic that has been very much neglected over the years. I've been in practice for about just on 13 years in this area, and it's very sad to see the kind of challenges and, quite frankly, as the poster said, families torn apart by proper planning not having taken place, really, from that point of view. So the topic is apt, and I think more should be done in terms of the education through the masajids in this arena, and therefore I actually compliment the Gatesville Masjid today. As you know, in the Quran, there are various, it's a form of codification, and there are various instructions, how to perform various acts and pay your zakah and all that. But as Sheikh has alluded, there are many verses that talk about inheritance, many verses that talk about the executive's role in the Quran, and that in itself should spur us to look at this topic a bit more closely. Ultimately, the verses that end up in the final codification of inheritance is, as Sheikh has indicated, in Surah An-Nisa, and that's the final codification. And whether we want to adapt that within a South African situation and improve on it in terms of certain rights and so on, that's fine. But the point is, the essential point is, there is a form of a codification and a process how an estate must be dealt with, as Sheikh has alluded. Sheikh has indicated, you've got assets, you've got liabilities, you've got the concept of wasiya, and then the inheritance goes on between what we call prescribed and residual heirs, really. So the first point I want to make to you is that the Quran is there, the Sunnah of the Prophet ﷺ has related various hadith, again, that Sheikh has quoted, and therefore we should get back to this and contextualize it within a South African context, really, from that point of view. The second point is that I think it's very important that you realize what's happening currently with the process of an estate. No estate takes less than 2 years to completion. Simply because you know what's happening with the government departments, really. 2 is, in many times, there are disputes which delay the estate process. That takes it to 4 years often, really. In some cases, we don't even get out of the starting blocks because there's a dispute at the start point, really, from that point of view, really. So the point is that it takes 2 years at least to get this process and to get heirs the benefits, really. So I think it's very duty-bound on you to make that process as effective and efficient, really, from that point of view. And one of the manners that you really should be considering is to do this restructuring in your lifetime. If you're concerned as sisters that you're only going to get 1/8 of the estate when there are children, then engage your husband and restructure in your lifetime. It's permissible. If you are very clear what you want to give to your children, then restructure it in your lifetime. Seriously consider that, because this estate process is becoming very tedious, very dogmatic, really. People don't answer queries and so on. And at the end of the day, those who are entitled to the heir, to the inheritance, even from the day you pass away, are then denied it almost for 2 years and are deprived of the benefit of that, and that can have damaging effect. I want to put this whole thing together, as the chairperson said. Often when we have these sessions, we talk about the concept of wills, and we concentrate so much of wills, really. But an estate process, an estate plan is much more about a will. I've put, in preparing for this, I've put an acronym together called PICS. PICS, for you to remember. Go home and just remember the word PICS, and you will remember the whole presentation. What does PICS stand for? P is for a plan. I is for information. C is for communication about your plan. K is about knowledge that you must gain about how its whole process of what does a Sharia inheritance means, what does wasiya mean, effectively. And S is a spiritual dimension to this always, and support to the family who has had the bereavement. So I'm going to cover each of those points for you easily. And you must have heard a lot of these points, but people get so obsessed with just doing a will, and they don't look at the other considerations. Can you believe it? I mean, I was appointed an executor in a relative's estate. I was appointed, believe it or not, 40 years ago, and 40 years later I find out that I'm an executor of my relative's estate, and we see each other every month and so on. Unbelievable, unbelievable that you can go through. So I think that if you look at this PICS concept, and if you apply these ingredients of the PICS, you will minimize, there's always challenges in an estate, but the whole idea is to minimize the issues, minimize the disputes. If you see you're going to have a dispute, tackle it whilst you. Do not leave it for the executor as it. So the first point is P for plan, and the most essential plan is a will, effectively, as we know, really. Those of you who have bigger, substantial wealth, we can expand that into a will and a trust and restructuring and all those kind of things. And the essential part of a will is that it must be in writing. Let's start there. 2 is it must be signed properly by the person, the testator, making the will. 3, it must be witnessed properly. Be very clear. No will, from a practical point of view, it's a nightmare. The original will has to be lodged. You can't have certified copies that you're going to keep and you're going to find. Lately, the thing is, the will's disappeared, really. And there was a will, but the will has disappeared. We can't find it, you know. Please put the will in a safe custody place. Because often you move house, you change cupboards, and you move the will, and you can't remember, and the next person can't remember. Leave it with the person who does the will. They will have a will safe. Lock it up with a bank, lock it up with a professional person, and so on. And finally, be careful of the free will. You can't imagine that one standard free will apply to all of you here with different circumstances. And what amazes me most is that a lot of people have wealth, but they're not prepared to spend 5,000 rand seeing a professional to draft and make sure a will is. That can't be the case. You're creating problems. You're really creating problems for yourself, and you then want to say afterwards, how did this happen, already from that point of view? So the second point that we talk about under PICS is information. Any estate process is about information. Don't fool yourself. It's about information. From marriage certificate or antenuptial contract, from IDs that mustn't be lost, right? From the VIN number of the car, from the credit card number, from the investment number. We're not interested in the value. We're interested in who is the money with. Oh, it's with Momentum. What is the account number? Because it's very easy to write to Momentum and say, Mr. X has died, and this is the account number, and what's his balance? All right? We're not interested in the balance. We're interested in the details of the information. Gather this information at least once a year, update it once a year from that point of view. You can't neglect this area and then expect things to be efficient. Information creates a delay in the 2-year process. Remember that. Because by the time we write to Momentum and Momentum does a search and they reply 3 months later. That's how it goes these days, whether you believe it or not. But if you write and say this is the account number and so on, then they'll respond very quickly, effectively, from that point of view. Tax matters is delaying estates like anything. If you're behind with your tax matters, no estate can process until all the liabilities, as you have heard from Sheikh, are determined. And the tax man wants his pound of flesh. And that's a liability in your estate. So if your tax returns haven't been done for 3 years and 4 years, how do you expect somebody to complete your tax return when you're in the grave? You're sitting with all the information, really. Okay? So my sisters especially, push your husbands along these lines and say, where are this set of information? Have a copy of everything. We have on our website, you're welcome to visit our website. We have an electronic document, we call it the personal information, and you can enter all the information electronically, and you can maintain it yourself and keep it yourself, and when something happens, you just use the information. At least update it once a year, really, from that point of view. So the next one is C, and it's communication. Firstly, communicate with your own family to say you have done a will, and they don't need to know exactly what they're going to get, really. But tell them there's a will, there's a Sharia will. If you've got an adopted child, it has a different implication. Okay? It has a different implication. It's not a child from a Sharia inheritance point of view. Make provision for him in the Wasiyah clause, as Sheikh has given. Because a Wasiyah you can give to anybody who is not your compulsory, your Quranic heirs, effectively. So you use the Wasiyah clause for that, really, and give him an amount as you determine, or and then work out that the amount is equivalent to what the children would get, but not exceeding a third. So the point is, communicate with your family what the intention is. And once you see, when you communicate, you're going to see the rufflings. And once you see the rufflings, then you must go into action. Don't leave that problem for the executor. Why do you want to leave that problem for the executor, really? If you see rufflings, then you must handle it, really, from that point of view. And the next part of communication is, please tell the executors that there are the executors in your will. Please tell the guardians, if both of you and husband passed away, please tell the guardians that they are the guardians of the children, effectively, and what their role has to be from that point of view. So the next point is knowledge. As we've now expounded on the issue of knowledge, it's important for you to understand what the Sharia implications is when you say, I leave my assets to be dealt with on a Sharia basis. You need to look at your situation of your family and say, if I die tomorrow, what exactly is going to happen? On many websites, you can work out, you can get the proportions, and we don't need to go into detail, but essentially, the wife gets 1/8 when there are children, she gets 1/4 when there are no children. If the wife dies, the husband gets 1/4 when there are children, and 1/2 when there are no children. Careful with this one. When you have only one daughter, only a daughter, she has 50% of the estate. When you have 2 or more daughters, only daughters, no sons, they share 2/3 of the estate. But in that situation, often the uncles and the aunts are part of the inheritance. In other words, the wife will get, say, 1/8, and the daughter will get 50%, and the balance, whatever the balance is, will go to the brother and sister of the deceased. Now, you might not have known that. And you said, I want a Sharia will. Please spend time to understand what that means vis-a-vis your own family. And remember this, that the ratios and the proportions are determined the moment you die. It's not determined beforehand. You might think what it is going to be, but it's determined the moment you die. So let's give you a practical example. If I have a son, he will get 2-1 to my daughter. But if my son predeceases me, dies before me, my daughter gets 50% because she's the only daughter. Do you see how things change? Now, you might have said, I want to leave a Sharia will, okay, but your son is now predeceased. If he's alive, he gets 2-1 with the sister, but if he predeceases, look how the ratio changes. Your daughter gets 50%. The mother gets 1/8. The uncles come into play. If, however, the son was alive, the uncles don't come into play because the balance of the estate after the mother gets a 1/8 is shared 2-1. The balance is shared 2-1 between the son and the daughter. So the point I'm just making is just understand your situation. The final point I just want to make under knowledge is just be very careful that when you have got a predeceased child, in other words, my son has passed away before me or my daughter has passed away before me, it's not automatically that son's children or that daughter's children are going to get a share. Listen to this one very carefully. If you are in a situation where your daughter or your son has predeceased you, died before you, and left children, it's not, they do not step in the shoes of the predeceased child or predeceased daughter, and in most cases, they don't inherit as a compulsory heir. Especially the children from a predeceased daughter doesn't inherit on a compulsory basis. How do you provide for them? Sheikh gave you the answer. You provide for them through the wasiyah clause. You provide for them through the wasiyah clause. So the clause that we've developed in our wills, which many of you can take, and those of you are practitioners, we say generally, if any of my children have predeceased me, give to that child's children what he would have got as a compulsory heir, providing it doesn't exceed 1/3 through the wasiyah clause. So even if you don't have that situation, and it arises quickly on you, your will cover that situation because you have got a general clause saying that. We call that a wasiyah clause effectively. And it's a very important clause from that. Finally, obviously in knowledge, you also need to know how much taxes are payable, where's the money going to come from, and all those kind of things. If you know, if you have an estate of 7 million rand in your husband, we can make all the taxes eliminated by splitting the estate up between husband and wife, because you only pay above 3.5. So why go pay on 7 when you can give your wife the 3.5 and therefore you pay nothing? Only your family is deprived of an economic benefit. The last point that I want to talk about is the S for spiritual and support. I mean, we've covered the point that the Quran and the Hadith of Prophet ﷺ covers and says why and on what basis and how it should be. I think there's too little communication about this to the family members that inculcates this whole spiritual dimension. Because ultimately, the assets that you have belongs to Allah subhanahu wa ta'ala. When you pass on, it carries on. It's no one's permanent assets really. We're only the custodians, we're only the guardians of those assets really from that point of view. More importantly is the support that the bereaved family must get really. I think it's sometimes very traumatic. You must understand, the executors or the administrators can't be an end of support to the family. Family members have to. Okay? We will do the legalistic work, but when you go back and sleep, your children are not well, they need to go to school, there's no driver to take them to school, the executor doesn't take that kind of responsibility. So often I see that the support structure is just not there. It's just not there. Please do not take it for granted that that's all fine. You and we as family members must ensure that there is a proper support structure, because the deceased spouse goes through such a traumatic experience really. We've got a case now where somebody died very young, the husband died very young, 45 years old, and the children are about 6 and 7. And the wife is totally distraught. I mean, kids need to be taken to schools. For 2 years, there is nothing coming through. I need you to understand that, the danger with it, really. And these children's school fees have to be paid. Simple issues. The insurance of the house has to be paid. Simple issues. If you're not going to have insurance on the house and there's a fire, what's going to happen? Your medical aid has to be paid. So one of the issues that we talk about is restructure. Place assets on your spouse's hands so that you avoid that situation. Jazakallah, I'm sure there'll be many questions, and I'm happy to take.
Thank you very much, Shaukat. Very comprehensive overview in terms of will and planning. The first warning, and something I've also learned today, the first warning is that we need to be extremely careful who is going to witness the will. That's the first warning, and I'd like to feel that if we can just understand that. I never realized that if somebody that potentially can become an heir, if he becomes a witness to the will, there could be complications. So Shaukat, thanks for clearing that up. It's highly appreciated. A second question that's come through, it's a very interesting one. The person wants to know, can one have more than one original copies of a will? Can one have more than one original copies of a will? So if an attorney is drafting your will for you, and it's the same will, but there are two original copies of that will, is that permissible?
No, it's not permissible. More importantly, let's not look for trouble, really. I mean, so the answer is on a conservative basis, and no, there shouldn't be two original wills, really. There should just be one.
Should just be one copy. Okay, so ladies and gentlemen and viewers, I think it's a wake-up call for everybody that it's a very important aspect of our living and post-living that we need to get our issues all sorted out. It's a very complex situation, but we need to become more knowledgeable on it. Mohammed, question from your side? Sure. Okay. Are there any questions from the floor? I have a few questions on the phone, but any questions? Again, I just repeat, a question and not a statement, please.
Assalamu alaikum.
Salam.
To the last brother that spoke, I just got a question for him, inshallah. And that is, in the event or in the case where the husband passed away, and he leaves behind a wife and a daughter, you said then 50% goes to if he has a brother. Can I know what the reason is that for, Kanala?
I said, in this case, just for everybody, the husband passed away, there's a wife and a daughter. The daughter, in that case, in terms of the verse, gets 50% of the estate. It's in terms of the verse. All right? The wife will get 1/8, because there's a child, and the balance will be shared, so 1/8 and 50%, 1/8 is about 12.5%, and 50% is 62.5%, takes you to 62.5%, and the brother and sister of the deceased will share the balance on a 2-to-1 basis. Correct, Sheikh?
Is there a specific reason why the brother must inherit?
It's from the verse in the Quran. It's from, if you read Surah An-Nisa, I'm not sure exactly which verse that applies to, but it comes from the verse. It comes clearly from the verse, and the verse ends with ordained by Allah Subhanahu wa Taala. That's how the verse ends.
Yeah. With that inheritance, is there any responsibility on that brother towards the family?
Well, there's always a responsibility, particularly on the male. I mean, there's always a responsibility on the male. I mean, there is that case always, really, from that point of view. There is always. However, if you're in that situation and you know that that's going to happen on your death, you can, in your lifetime, restructure. And that's one of the elements people don't address in their lifetime. Are you with me? Okay?
Yes.
So as the sister has said, the wife in this case inherits 1/8. Are you with me? And the daughter's going to inherit 50%. If you restructure your assets in your lifetime, that process is much easier in the sense that your wife is secured and the daughter is also secured in that sense, really.
Yeah, okay, shukran very much.
Thank you so much, brother. Thank you so much. Any other questions from the floor?
Got a question over here, Satarbai. Over here.
Assalamu alaikum. Lately, you hear.
Can you just bring the mic a bit closer?
Lately, you hear, especially while you're living and you want to distribute your assets. According to some sources, people go to the ulama and they say that. So say some of the siblings they got enough. But there's one or two siblings that haven't got enough. So they tend to advise the person that.
Can we have the question, please, brother?
No, I'm saying is, can you actually change, not change the situation where you give the kid that hasn't got the means more than what the Sharia is saying.
You got the question?
Okay, shukran for that question. I take it you're speaking about not siblings but children. Yeah, so it might be there are sons and there are daughters. And as per Quran ayah number 11, as Brother Shaukat has stated, it says 2:1 between the sons and the daughter. But it might be that some of the sons are more okay than the daughters. In that instance, as was stated, during your lifetime you can restructure or you can make a gift. Right, so you can say, I'm gifting this to my son, that's a bit less, does not have lots of money. And also their advice would be then speak to the other children. Say, look, this is a situation, are you okay with that? Because now we speak about fairness between children. So that must also be discussed over and beyond the inheritance laws that find application once you pass away. That's one thing. But now you're looking at the gift during your lifetime. And there's totally nothing wrong in doing that. And in that instance, the ownership must just have transferred prior to you dying. Otherwise, it might be part of the estate and the laws of inheritance will then find application. Shukran.
Shukran very much. I think there was a question at the back from one of the ladies.
Assalamu alaikum wa rahmatullahi wa barakatuh. I've just got one question. The scenario, if a mother is no longer, there is a father with 4 children. The father then left a will, and then after the father left a will, the 4 children would be 2 sisters and 2 brothers. The father then passed on, the 1 sister then passed on after that. The father made a will, and in that will he excluded the 2 sons and left his inheritance to the 2 daughters and a grandchild. What happens in that scenario?
Got the question? Sheikh, would you like to?
Okay, shukran for that. I got the individuals. I think when you're referring to father, you're referring to the deceased and a widow and children. That's my understanding. Right, so if there was a widow and they were
Tamam, Sheikh.
confirmed,
No widow, only a father and 4 children.
so the person passed away leaving 1 father and 4 children, okay?
Yes, and then in that scenario, the sister passed on. So the remaining would be 3 children, which is 2 sons and 1 daughter.
Okay,
So the father left his will to his inheritance to 2 daughters and a grandchild, excluded the sons.
okay. In that instance, the will would not be Sharia compliant. And in that instance, I would advise the family to sit with a qualified alim to explain what the situation would have been, and they, between themselves, they have to come to some type of a solution. The bequest to the grandson, that would be a valid bequest, as long as it is not more than 1/3, that is all in order. The rest of the estate should have gone to the father with a 1/6, and the residue to the sons and the daughters in the proportion of 2:1. Shukran.
Another question at the back.
Okay, Assalamu alaikum. I just want to ask if one of my parents passes away and the remaining parent, is the remaining parent allowed to stay and live in the house for as long as she or he is alive? Or must the inheritance of the beneficiaries be paid immediately? And on to that question is, what if the remaining parent don't have the money to transfer the property or is not able to? What happens in that case? And I have another question is, can you please explain to me the security clause of the will and the importance thereof? Shukran.
Security clause for you, Shaukat?
Concerning you're referring to the usufruct, right? So in the will, the person might have said that I leave my estate according to Sharia and the Islamic distribution certificate and so forth. But as far as that house is concerned, my wife can remain in the house for the rest of her life, right? That is what is referred to as a usufruct. In a will, it does become a bit problematic. However, in terms of a gift, that is where it is totally allowed. It is referred to as an umrah, right? Like while you are alive now, you can register with the deeds office a lifelong usufruct in favor of any person, in favor of your surviving spouse for free, and that would then basically be a gift in her or his favor. Once you pass away, if that was the case, then you're entitled to live in that house for the rest of your life based on that umrah that had taken place, and you don't have to give that any part of that inheritance to them immediately. The house, however, can be transferred onto those other person's names in terms of Sharia distribution, but they don't have any right to stay in the house during that time. Doing that in a will, however, is not 100% Sharia compliant. Shukran.
The question of the money, they don't have enough money to.
Okay, in the instance where there's not enough money to transfer the property, I think that is where Brother Shogit comes in. But in that instance, they have to get the money from somewhere. They have to sell maybe an asset in the estate, maybe a car, or if there is some other money, or get some money in order to effect transfer of the property.
Maybe just to add to that point, and that's why I emphasize it's an estate plan, it's a succession plan. If you know you're heading for those kind of challenges, try and arrange things in your lifetime to overcome that from that point of view. Because otherwise the problem becomes an insurmountable problem. The issue really is, what I think the sister was trying to illustrate, that there isn't a Sharia will, there isn't provision made for the mother to stay, and so on. Go back to the drawing board, look what we've said today, and apply it and revisit. When you leave here today, revisit what is on record at the moment and try and secure those kind of issues not happening, really, from that point of view.
Okay. Very important question has come through now. Father, mother, 4 children, all living in a very happy relationship. Father passes away. After the janazah, the children come together with the mother, and they then realize that the will, first of all, is not a Sharia will, and that there are aspects of the will which are contrary to the lifestyle of a Muslim. The question is, can the mother, in consultation with the children, alter the wishes of the father? Because some of them are not Islamically compliant.
Yeah, so obviously a will is a will, and it's a legal binding document, really, okay? People must understand, a will is drafted in, maybe the attorney should have answered this question, but the will is drafted in terms of the Wills Act. There's an act that says how the will has to be done and how binding it is and so on. So to answer your question, yes, the will is binding, it has to be carried out in that manner. However, there are mechanisms after that process to redo things via re-signing agreements, via redonations, via other matters. But as far as the will is concerned, it's binding. I'm fairly certain my attorney colleagues will agree with me that the master will not accept any variation to that, but there are mechanisms. So if the minds are set to adjust it and redo it, there are ways of doing it. We've had an estate that was totally not Sharia compliant, but because there was a will to make sure it's going to happen on a Sharia basis, there was a whole reorganization after that. Cost some money and all those kind of things, but it's possible. I don't know if you want to add.
I just wanted to add, I mean, I don't know if it's going to be, there's one other thing that we also need to take into account, is that if you are married in community of property, and if in a polygynous, if it's a polygynous marriage, that also has consequences on how the distribution is going to be. One of the challenges is that is why in the case of Muatsa, the person had the Islamic will. Everything was done in terms of the distribution. The problem was that one was married in community and the other not. There the challenge was, even though the children wanted to redistribute, even though they wanted to give back, the problem was that the share in terms of South African law at that point in time went to the wife that was, everything went to the wife that was married in terms of in community of property, and that is where the dispute came. Currently it's changed, But I'm not saying that many of these other permutations will come up, and it's very important that you do estate planning to be able to ensure that especially your wife and your children and minor children are not destitute once you die. It is a major challenge because it will take you almost 2 years to be able to get any funds, and you need to be able to ensure that the transfer, etc., goes to the wife and those that it's supposed to. Shukran.
Question here.
Assalamu alaikum wa rahmatullahi wa barakatuh. The element of adoption was discussed earlier on. The element of illegitimate children. Does it apply the exact same for male and female where the wasiya is concerned?
Okay, your question is concerning adopted children and children conceived out of wedlock. Yeah, so in that instance, if you have a Sharia will, for example, would those adopted children be entitled to in terms of verse number 11 of chapter 4 of Surah An-Nisa? The answer would be no, because those children have their biological parents. So African law ever puts a spin to it, because it says that the biological parents or the natural parents lose all their rights, and the adoptive parents gain all those rights. There is then the conflict between Sharia and South African law. However, in that instance, you can bequeath as a wasiyah to your adopted children, as well as to the children conceived out of wedlock. Bear in mind, the child conceived out of wedlock is only with regard to the father, not to the mother. That child will always inherit from the biological mother, even if that mother did not marry that biological father. The fatwa of the MJC in this regard is if that child was born 6 months or more after the nikah, that child will also inherit from the biological father. Yeah, shukran.
Okay, shukran for that. Question over here.
With regard to the 2:1 rule, no, it doesn't apply to the wasiyah. Yeah, shukran.
Mohammed?
Yes, Darbai, I've got 3 questions, if I may.
We want to leave before Maghrib.
Shaukat said it's okay. The one is that the father wants to exclude the son because he's a drug addict. What can we do from a Sharia perspective to protect that son because he's a drug addict? And the father, obviously, whatever must go to him must be protected. That's the one. The other one is that we find cases where the son will come and the son will say, my father left my mother, so she was in an abusive relationship, he had nothing to do with our rearing us as children. I want to exclude him from my will. Second question. Third one is, it now comes to the state where the wife has given up her career. She was a doctor, gave up her career to rear the children, and she's going to inherit 1/8. What can be instituted in the will to make sure that she gets more than the 1/8 for what she has contributed towards the estate?
Those are 3 very formidable questions.
So in the case of the first one, I'll give it a bash, the first one and the third one. The first one was about the drug addict and so on. I think in that case, what we institute in that mechanism is that all his inheritance, we actually specify it, must go into a will, to a trust for him. And we put some guidelines as to how he must get the benefits out of the trust and so on and so on and so on. So the trust will come into play when the father or mother dies in that case. So, and you apply that principle again for anything else that needs protection. For example, a disabled child. Similarly, you would want his proceeds to go into a trust, really. So use the trust mechanism, bit costly, but it's the safest mechanism, really. The last one was, Oh yes, I actually slipped up, and I must apologize to the sisters at the back. I slipped up mentioning this. I must emphasize to the sisters, there are many sisters these days that spend money when in fact it's a husband's duty to spend money to nafaka her in that case. They often pay towards a bond installment, they often pay towards the school fees and so on. And I think, I want to say this, that you've got to start making notes of those kind of things unless you have done it out of love and out of your well-being for your husband. If not, please do keep a record of it. And this is a serious matter because often this happens, and there are many wives that are working these days, there are many professionals and so on that contribute to these kind of things. Because in the estate process, as Sheikh had indicated earlier on, if you have a claim, it comes out as a liability before the proportions take place. It comes out as a liability before the proportions take place. So it's important from that point of view during your lifetime. Secondly, if you've contributed to the wealth directly and indirectly, bring your husband to me and we'll sit down and I'll make sure that some portion of that wealth is allocated to you in your lifetime, because the good thing about it is, and we're now going to tax, there is nothing to pay when you transfer assets between husband and wife. No taxes to be paid other than transfer duty in the case of a property, really, okay? So that's a fortunate part of that kind of restructuring, really. So if that is the case, you've got to be proactive in this area. It's very difficult once the will says a Sharia will for you to come to the table and say, no, I've contributed this, I built the garage at the back to the house, and they're going to get 7/8. Record it properly, let it be a claim, and if you want to, during your lifetime, restructure so that you're not in that position.
Okay, if I can just add on to what that sister said concerning the 1/8. In that instance, in the event where you have contributed towards a property, the issue is always, was it a gift or was it basically a loan? As Brother Shaukat has stated, rather have a default position in your marriage to state that I know it's the responsibility of the husband to pay towards all of these finances. However, if I do give it, it would by default be a loan unless I say otherwise. Then at least you have that on record. Another instance that could apply is if, for example, she left a doctor employment as a doctor for many years, and now he says, but now everything is in my name and you are only getting the 1/8. He could, however, make use of the mechanism to increase the dawah, because sometimes it's expensive to transfer property and all of these things. So he can say that, Duki, right, that I gave you at the time of nikah, I gave you 400 rand, all right, now I'm going to increase it to 1 million if you agree there too, right? So now you are owing her 4 million rand. So if you pass away, she claims that 4 million rand as a liability. So these are things that, discussions that can take place in situations like those.
I just heard Siam saying at the back, ladies, wake up, it's time to claim your rights.
Salam.
Okay, in the instance where the father was an abusive parent, the Quranic ayah is quite clear that the father inherits 1/6 of the estate. In that instance, the father would inherit that share, and it might just be when he inherits that share, you will change his ways in future and make dua for the deceased. But unfortunately, unfortunately, that is specifically what the Quranic ayah says.
Sheikh, another one here, which I think I would like Sheikh to answer. It says, just get my phone on quickly. Assalamu alaikum. Can you please ask Sheikh, what does the Quran say? If the will is not Sharia compliant, how does it affect the deceased in the barzakh?
Obviously, in the instance where if you look at ayah number 11, 12, it gives certain directives. In ayah number 13 and 14, it speaks about the consequences, and you can go to those verses in Surah An-Nisa or chapter 4, sorry. If, however, the person intentionally did so, right, you're not entitled to do so. Besides now restructuring as referred in estate planning, you're allowed to increase the dawah, you are allowed to make a bequest and all of those things. But if we intentionally go against those verses, right, 11 and 12, 13 and 14 gives very dangerous consequences. what should then be done is the family should sit around the table. And if, for example, the father said there's a son and a daughter and they both get equal shares, there's nothing that prevents that son from saying, all right, if those were his wishes, I have no problem with it. I have lots of money, so I give you that as a gift from my side, and they can both inherit equal shares. Even per Quranic injunction, you can't make a bequest to a compulsory heir unless, however, the remaining beneficiaries consent. So if they sit around the table and they all consent thereto, the matter can also be sorted out and the father will not be held responsible. As Brother Shoka stated at the beginning, we don't really own these assets. This is Allah's assets. Ultimately, we have it for a specific point in time. And once we pass on and we haven't taken it out of our ownership, then Allah says this is what should happen. After, obviously, we have the discretion with the 1/3. So to answer the question, I would advise, sit around the table and see if some type of a solution could be found.
Okay, time is marching on. We're going to take 2 more questions.
Assalamu alaikum.
Salam.
I say shukran to Quds for the first allowing us a forum like this, because out of Brother Sokat picks that you spoke about, I'm looking at the knowledge part. This is a little bit broad in mine. And then the first sister speaker, I was just going to add a little bit on that one. And then in the last brother speaker on that side, I also want to add about what the sister was saying. My question is, we go back to the father that lived a South African context world, not Sharia compliant, where the sister of the 2 sisters has passed on. What happens to her shares? And on the last one, there's a brother of the 2 brothers that was not included in the will. That's a drug addict. That's 2. And 3, that the brothers does not want to have anything to do with the sister that's still alive. What do we do in this instance?
Do we have those questions?
The first one was, I've lost the first one already.
The inheritance of the sister that passed on.
Yeah, so that's a good point. The point was, what's the situation of the sister that's passed on and the father dies? Eh? Did the sister die before the father? No, after the father. After the father. No, then she will get her share of the inheritance and it will be dealt with in terms of her will. So the father's died, correct me, and the sister dies after that and the estate is not wound up, I presume, and the other sister is alive. She will be entitled to her share and it will go through the process, and what her will says will then include that portion from the father's estate. That was the father that left the will for the 2, and the grandson, the 2. Yeah. So the point is this, and this is the challenge that you have to address. A will is a valid document. You have to follow the instructions of the will, really, effectively. You cannot come afterwards and say that it should be on a Sharia basis and the master must entertain that argument. So the will carry out the instructions. So in this case, if it is to the 2 sons, for example, it will carry on. Whether they voluntarily want to do a redistribution, the rearrangement, and as Sheikh and my sister here said to me, that's possible. It has certain consequences for costs and all those kind of things. But if you want to avoid the consequence of the deceased father in the barzakh, as Sheikh has alluded, we encourage you to reorganize things in a way that achieves that really. But if they don't want to agree to that, then it stays as it is. Really. The other question was, I can't remember the other question, I must be honest. Sorry? What about the question? No, it's about the drug addict, you said.
The contribution of the sister that passed on was probably her shares was going to go to the brothers that's still alive, but the father excluded them out of the will. Yeah. But one of the brothers was a drug addict, so I was not sure on that one. What happens to the sister that passed on the, her heirs? What happens to her?
No, the point is really is the will says the two brothers must inherit, please. That's what's going to carry on. Whether the sister's alive or passed on, that doesn't come into play. The will is binding. The important thing about the brother that's on drugs, if you did not say that this has to go into a trust, Sheikh, I'm not sure whether one can apply to court to arrange for that, really, as an executor. No? Very difficult. Very difficult. So the point is, the money will be wasted by the brother who's on drugs, really, from that. That is why, again, if you go back to my points, it's not about the will, it's about an estate plan. Assess what your situation is and do things accordingly. Sorry, brother, man. I hope that answers some of your questions.
Okay, the brother in front here.
Assalamu alaikum, everyone. I really enjoyed the session. I actually do work in the financial services industry as well, so it was nice to come here to get a bit of the Islamic context, because most of the work that I do is more in the secular system, if I can call it that. I just have a question in relation to trust specifically, because like in the industry, we can sometimes say that with trust, you can be seen to be ruling from the grave, whereas from what I've heard today and what I've previously understood as well, Islamically, that I'd imagine that's not supposed to be the intent that you should have. So how should you structure a trust so that whatever you're stating, if you're using a trust as part of your will, whatever you're stating in there, you can't be seen to be sort of being too influential on what's happening here after you've passed away. So that's the one question. And then the other question is maybe just in relation to restructuring during your lifetime. I can see how that can work quite well if it's just between spouses, but I'd imagine would there not be a complexity when it's a restructuring between kids, because there's no sort of allowance or freedom that's given there, whereby if you pass on assets to your kids, there could likely be donations, tax implications, and those things which probably could make it complicated. So yeah, I just want some context on how to deal with that.
A very good question by the brother. The first one was about trust. So the point is that if you are very clear that the Sharia principles must apply, you draft the trust deed with Sharia principles. In other words, you say on the demise of the planner, the clause relating to how these assets are going to pass on will be with effect within the ambits of the Sharia law, and we put the same clauses about certification and everything into a trust deed, really, from that point of view. And if the beneficiary in that circumstance wants to take his assets out of the trust, he bears the consequences of the taxes and so on. So the Sharia, the clauses that we introduce into the trust deed are very akin to the Sharia clauses. We also say that zakah is payable on these assets, because in substance, the assets in the trust is the planner's assets, in substance, really, at the end of the day. Are you with me? So we do that to answer that part of the question. The second part of the question is a very valid question, that whenever you restructure in your lifetime, restructuring between husband and wife has no tax consequences. It may have, only in case of property, a transfer duty payable, but there are no other consequences from a tax point of view, with the donations tax, with the capital gains tax, and so on, really. Okay? However, when you restructure and you want to pass on to children, right, I think we discuss that in depth. Firstly, do you want to do it? You understand that you're passing on the assets. It's not yours anymore. You've got to understand that fully. Then we use Section 42 of the Income Tax Act. Section 42 allows you a restructuring. Okay? It's a very convenient section. But you have to be very clear what you want to do. Are you with me? Because to retract it and so on is a very difficult process, really. I'm not one keen to restructure where the planner parts with all his assets. I'm never keen on that, because you never know in a rainy day when the planner needs assets. But if you're very clear that you've got substantial assets and you want to part with quarter of them already to your children, there is mechanisms. If you fail the mechanism, you pay the price. However, you are going to pay the price on death. Because on death, those assets are going to be in your estate. So you've got to make a call. Do you pay the price now and create certainty, or do you delay it and have it part of a Sharia inheritance? So it's a kind of debate. You must consult with your consultant and come to a decision, really. Okay.
Thank you. Very clear-cut answer there, Shaukat. Thank you so much. Mohammed?
Assalamu alaikum. I have a few questions. I just wanted to know. My father had a will before he went for Hajj. Then in the will, everything was left to his wife. Then my mother passed on before him. So her estate, obviously, because my parents were married on community of property, so obviously her estate wasn't settled. So how do we go about settling her estate first? And now, especially after my father has passed on, and we couldn't find a will that is updated. So basically, the first will that that was drawn up was everything was left to my mother. But now my mother passed on before he passed on. So now he passed on, but now there's no will of my father. Now my sister has been living in his house for almost 30 years already. She's been the one that's been taking care of both my parents. Now I want to know, obviously we had to follow now the South African law where the masters had taken over. Do the house have to be sold with my sister living in the house? She's been living in the house, like I said, for almost 30 years. Now she cannot afford any other accommodation. She cannot afford anywhere else to go and live. What happens in that case?
Yes, can I just, like I've said, if there is absolutely no will, then it goes in terms of South African law, intestate succession, and there is a very clear formula, as you would know now, if the master has been involved already, how it gets allocated. What you can do is, the asset, if the asset is a house, and more times than not, it's only one asset, sometimes it's really not millions, it's one asset in the house, which is the house. The challenge is that there can be obviously a transfer, but it doesn't mean that your sister has to be evicted. The challenge is that we need to, this is again where I'm saying estate planning or plan. You need to be able to, if you know, place a usufruct, or alternatively, you need to ensure that these issues are dealt with before you die, because the consequences can be that the house needs to be sold for many reasons, besides the fact that the heirs, the intestate heirs, the children, all of them want their share. And the master is going to say that either you come up with the money or you sell the estate, or you sell the house. And that's the challenge. Unless all the heirs come together and they agree that the sister will be able to live there, it will still be transferred to them, subject to a usufruct. But sometimes we know, the possibilities, especially if there's more than two people, that it's going to happen, might be very slim, unless they know the consequences of it not also being an Islamic distribution.
Thank you. Mohammed,
one more.
Is that the last question?
Just one more, yeah. We just want to limit when just hold on, just keep it.
Sorry. So while the sister are still living inside the house, can the assets that is inside the house be sold while she is still inside the house?
I think that's a legal question. It really is a legal question. It's something that more...
That question, there's a lot of answers.
Yeah.
Depending on which route you want to take.
Okay, we'll just take two more. Gentleman at the back, and then this young man here, and then we're going to wrap it up.
Assalamu alaikum wa rahmatullahi wa barakatuh. Is there advised criteria for choosing an executor? And if you can just briefly sketch us, what are the rights and responsibility of an executor?
Good question.
First question, what's the age of a child to be an executor? Eh? Is that what was that? The first question. Criteria. Oh, criteria of an executor. Of an executor. Look, the point is, the criteria is generally that the person obviously has to be matured, of sane mind, and so on, and matured, and so on. And I think the minimum age is 14, if I'm not wrong, to be an executor. When they said possibly. So there's no difficult criteria to be quite frank. And I think the point is that you obviously want to select somebody who's of good standing, who's to be, I mean, even the verse in the Quran says that, you know, those who are going to be the executors, they must carry out their duty honestly and justly and so on. So you're looking for somebody of that caliber, really, from that point of view. So I always recommend that there is a family member as an executor, plus the professional company that you wish to appoint, really, from that point of view. And one of the points that we should also make is that also try and negotiate these fees beforehand, as opposed to being stuck in the mud when the world is saying that legacy is the executor and you don't negotiate the fees, really. So that was the first part of your question, isn't it? And the second part? The rights and duties, obviously, of the executor, it's a big responsibility. There's a difference between the executor and the administrator. Sometimes you don't appoint the administrator, you appoint the executor as the administrator also, okay? So the executor has the duty to make sure that the duties of the instructions of the will is carried out, essentially, and timelessly and efficiently from that point of view. Whether he's got the skill set or not, or whether he uses somebody like a company or attorney, that's his prerogative. But the most important duty is to assure that the instructions of as per the will is carried out most efficiently and effectively, and that obviously he does his work on an honest basis and so on, really. So that's the function of an executor. More powerful than the administrator. For example, if a property has to be sold, he will have the final say whether it will go through or not. Obviously, he has to take into account what the interests of the heirs are and so on. So it's quite a responsibility to take on the role of an executor. And hence, I say that when you appoint somebody as the executor, please let them know. Because they may say, listen, look, I don't want to be involved in this. Why do you want to appoint me and so on, okay? But once he's in and the will is valid, I mean, he will be the executor in the will.
Shaukat, can a be an executor as well?
Yes, he can be an executor. There's no problem.
Okay. All right.
Just one thing. One of the gentlemen asked also clarification. The lady asked if there's a security clause in the will. What's the impact? It wasn't answered earlier.
Yeah, often there's a security clause in the will where in other words, this applies to the master, really. Maybe the attorney should answer this.
Basically, with regard to the security provisions, so sometimes the Master of the High Court, if it's a person that has been nominated in the will, the Master would require that security would be put down, and that would come from the person himself at the moment, and later on it's then taken from the estate. Now that is sometimes a slip. So in this instance, where you agree that the person that you have nominated to be the executor does not have to put down security, so that is then waived. Certain persons are also automatically waived, like a surviving spouse. But if the person that you are nominating is not a surviving spouse, or those persons who automatically is waived in terms of the law, then this clause would then make it possible for no security to be set. Yeah, thank you.
Assalamu alaikum wa rahmatullah. First, I have two questions. The first one is you spoke about the structure, the restructuring in your lifetime. Now, when it comes to a debt owed to the spouse, like the wife that contributed, she left the work, contributed to the marriage, how would you structure that? Do you do that in the will, or do you have a separate document stating that you're attached to the will? How would you recommend going about that? And then the second question is, can an heir renounce their share and then gift it to anyone of whoever they choose, or does it have to be once they renounce their share, does it have to be split according to the Islamic law of inheritance splits?
Okay, concerning the husband and wife and restructuring during their lifetime, it depends what mechanism they will be using. So if you want to put your wife in a better situation, you can transfer the house onto her name, and that is hers. Or alternatively, you can grant a lifelong usufruct over the house, that would be hers. Or alternatively, you could increase the mahar, the maskavi, the mehr, and then that would mean that she's entitled to claim that from the estate. So depending on what mechanism would work for you in your situation, by mutual agreement between both spouses, that could be done.
But that's essentially outside of the...
That is outside of
the
the
will.
inheritance, yeah. So that would basically be complete transfer, with the exception of that liability with regard to the dowry. The second question?
The second one is, can an heir renounce their share and then stipulate who that share must go to?
Okay,
or does it have to go according to Islamic law of inheritance splits?
Regarding the renouncing a share in inheritance, if it was a bequest, a wasiya, you can say, I don't want it. That can happen. It goes back into the estate. Right? That is now a wasiya. However, as far as the compulsory beneficiaries are concerned, they are entitled in terms of Quranic injunction. That is theirs. Right? So they can't really say they don't want it. They can, however, don't even have to accept it. Because if, for example, the person passes away, and 10 minutes later, the beneficiary passes away, not knowing whether accepted or not, automatically it forms part of his estate and then devolves in terms of his will and so forth. So you can, however, state that I'm now giving this as a gift to another individual. The only, there is a case, the Musa versus Haneke case, where they did the renunciation, where the person left behind an Islamic will, in terms of Section 2C of the Wills Act, the children said that we don't want it. An automatic consequence of that, if a descendant renounces the right, automatically goes to the surviving spouse. Right? That was the issue in that case. From an Islamic perspective, that could also happen on condition that they are giving it as a gift to the mother and not saying that they don't want what they are entitled to in terms of Sharia. The end point would be the same. It's just basically how do we get there.
So you can't actually renounce, you can just, you accept it and then gift it.
Yeah, you accept it and gift it, yeah.
I've got one question. I think it might be of interest of the participants here. How do we use the retirement funds, etc.? You nominate beneficiaries there. Is that the will, does it override what the will states? And how can you use that to kind of liquefy or make your estate more liquid in the short term while the will is being executed?
So just to clarify, any benefit under a retirement fund or a provident fund or a, what's the other category? There's a third one. Retirement annuity also, and there's another one. Reservation fund. The instructions take place based on the instructions given there. It's got nothing to do with the will, because those assets do not form part of your estate. So it's a very good question that you're asking from that point of view. So your instructions in that area, and maybe the financial planners are more competent to answer this, goes by your instructions. But having said that, the trustees have the final say. The trustees of that fund, the pension fund, the retirement annuity, and so on, have the final say. So for example, I've seen a case where there's a minor child and the other children are adults, and maybe the minor child was born of a second marriage. Although the instruction was in a certain way, they preferred the minor child to get the benefit out of the pension fund and provident fund, because the minor child's needs are far greater than the adults, for example. So just be careful that whatever your instructions are still subject to the trustees, and more importantly, it doesn't form part of your estate, and therefore it's not part of the taxes to be paid and all those kind of things. And that liquidity process carries on immediately. But that process only starts, and this is another important point, that process only starts once you've lodged your papers with the master, and the master has given you the letter of executorship. Okay? Now, often the master takes time to issue the letter of executorship. Okay? And again, There are many clients who come to us and says, we only want to start this estate process after 40 days or after our iddah period. There is no need for that. Start your estate process, in my humble opinion, 7 days, no requirement, but 7 days, please. And all the estate process needs for commencement is forms to be filled in and a guarantee that there's 250,000 and in an asset in the estate. It doesn't need the bank balances, it doesn't need the assets, it doesn't need the list of the assets. You can just declare one property and say it's far greater than 250,000 rand, and you can start the estate process. But if you delay the estate process because of very cultural issues and so on, you are just prolonging the estate process. So sisters particularly, be careful of that. There is no need to delay the process, start the process, because the government departments in this area are in a shambles, to be honest.
Thank you. Ladies and gentlemen, I think the moral of the lesson today is it's time to wake up. Life eventually will come to an end. Don't leave problems behind. That, I think, is the moral of the lesson. We have very, very good expertise in the community. Shaukat, Sheikh, Shiham, Sheikh Abdul Rahman, and many other people around here. Let's make use of them. In conclusion, I'd like to call upon our chairperson, Muhammad Abdullah, to move the vote of thanks, and then I'd like to call upon Sheikh Abdul Rahman to offer the closing dua, inshallah.
Bismillahirrahmanirrahim. All praises to Allah subhanahu wa ta'ala. We pass our peace and blessings to Muhammad sallallahu alayhi wa sallam. Respected youth, elders, brothers, sisters, and youth, I greet you in universal greeting of peace. Assalamu alaikum wa rahmatullahi wa barakatuh. Firstly, we have to thank Allah subhanahu wa ta'ala for providing us the Quran as guidance. These experts have spoken a lot about what's in the Quran, what guides us. I think let's use that. And Allah has supported us in terms of that. Our families need to be educated as well, and that's what the session is here today. So I just want to thank Sister Siam Shamai, Sheikh Munir Abdul Rauf, Brother Shaukat Mukaddam, our Sheikh Alexander, and Brother Siddhar Parker for all being participating in this event today. We look forward to presenting another seminar next week, so please join us. I'd also like to thank you, the participants, for your questions. It's been very intuitive and also giving us some more insights into the complex nature of this topic. And special thanks to Siddhar Parker. He's played an instrumental part of pulling together the seminar, getting the right people on board to play as a panelist. So shukran to you, Siddhar Bhai. Shukran to the masjid staff and the center manager for providing the facilities. There's no charge for this event, but if you'd like to donate to the masjid, we've got a young brother there that's sitting at the table. So please, you're welcome to donate something if you can. Shukran jazilan. Assalamu alaikum wa rahmatullahi wa barakatuh.
Just a quick one here. Legacy invites you to a Sharia-compliant estate planning seminar, a practical approach, Sunday the 16th of April. Facilitator Bashira Hendricks Khamildin, speakers Sheikh Munir Abdul Rauf, Romana Mahmood and Shaukat Mukaddam. Venue Islamia Auditorium from 10:30 till 12:30. I think this flyer is around. I did mention that we're having another seminar next week, a completely different topic, but I think it's something that's uppermost in the minds of each and every one. The country is in turmoil. Everybody is worried about your future, your children's future, and your grandchildren's future. So we're having a seminar next week on Sunday at the same time. It's called South Africa, Your Future, What Future? South Africa, Your Future, What Future? We have Bashir Adam, who is the CEO of next year SAB&T, very well-known firm of chartered accountants. He will give the economic perspective. And we have Ibrahim Faqih, a political analyst, not a politician, but a political analyst, who will be giving us an overview of the political situation in the country and which way the country is moving, and trying to give us some sort of unraveling a picture for comfort in terms of all these problems that we are facing with in our country: crime, corruption, load shedding, etc., etc. So that takes place next week, inshallah, at the masjid. between 1:30 and 3:30. I'd like to call upon Sheikh Abdul Rahman to offer the closing dua, inshallah.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر صدق الله مولانا العظيم وصلى الله على سيدنا محمد وعلى آله وأصحابه أجمعين وسلام على المرسلين والحمد لله رب العالمين والسلام عليكم ورحمة الله وبركاته.